For 14 months, I forgot names at dinner, repeated the same story about my first job, and lost my keys twice a week on purpose. Marcus started calling me the old man when he thought I couldn't hear. I heard everything. I remembered everything. Every whispered conversation in the hallway, every impatient sigh he swallowed at the dinner table, every glance he exchanged with his wife when I asked a question I had already asked 10 minutes before. All of it catalogued, cross-referenced, and filed away in the same mind that had once balanced a publicly traded company's 9-figure general ledger without a single material misstatement across 4 consecutive fiscal years. My son thought he was watching a man disappear. He was actually watching a man work. My name is George Whitfield. I am 71 years old, and I spent 40 years as the Chief Financial Officer of Hartwell Meridian Logistics, a publicly traded freight and supply chain company headquartered in Kansas City, Missouri. When I say 40 years, I do not mean 40 years of sitting behind a mahogany desk, signing documents that my staff had already reviewed. I mean 40 years of sleeping 4 hours a night during quarterly closes, 40 years of memorizing the specific cadence of fraudulent entries, the way a forged number carries a subtle wrongness, the way a forged signature carries a tremor. 40 years of building an internal architecture in my mind that processed financial data the way other men process breathing. Automatic, involuntary, and deeply precise. I started my career in 1978, at 21 years old, on the loading docks of a small freight company in Overland Park. I wore steel-toed boots and a canvas jacket, and I manually logged shipment weights into a ledger book with a ballpoint pen that leaked blue ink across my right thumb from October through February every single year. I tell that story a lot. My family heard it so many times during the 14 months that they began finishing my sentences for me, a courtesy that worked in my favor in ways they never once suspected. I was a man built from the inside out by the logic of numbers. I did not trust intuition the way poets trust it. I trusted pattern deviation. I trusted anomalies. I trusted the particular silence that settles over a financial statement when something inside it has been deliberately hidden. I had spent the better part of 4 decades training myself to hear that silence, and no amount of aging was going to quiet that instinct. My body had slowed. My knees were stiff in the mornings, and I required 2 cups of coffee before my hands stopped carrying the faint tremor that had arrived uninvited sometime around my 68th birthday. But my mind had not slowed at all. If anything, it had sharpened with the specific ruthlessness that only stillness produces. What Marcus never understood was that the most dangerous auditor is not the one who charges into a room demanding records. The most dangerous auditor is the one who sits quietly in the corner, looking confused, asking where he left his glasses, while his mind photographs every document on the table. 16 months ago, on a Wednesday morning in late October, I received a credit monitoring alert on a secure email account that Marcus did not know existed. I maintained 3 separate accounts. He knew about one. I had learned over a long career watching people in positions of financial trust gradually convince themselves that their actions were invisible, that the most critical information in any investigation is almost always delivered to the address no one thinks to check. The alert was routine in appearance, a simple automated notification from one of 3 credit bureaus I monitored. I read it in 11 seconds. The alert indicated that a new commercial credit obligation had been registered against my personal financial profile. The creditor was an entity I did not recognize. The language categorizing the obligation was unambiguous to anyone who had spent decades reading the fine print buried in commercial guarantee instruments. It was a personal guarantee on a commercial debt. My name was listed as the guarantor. I had signed no such document. I set my coffee mug on the kitchen counter with the particular care of a man who has just heard something shift inside the walls of a house he built, and I went to my study. In the hours that followed, I pulled the threads. I accessed my full credit profile and cross-referenced the creditor's registration information against the Missouri Secretary of State's Business Entity Database. Publicly accessible and remarkably detailed, if you know how to read the organizational layers used to obscure beneficial ownership. What I found, buried inside a limited liability company I had never encountered, was a document bearing my signature on the guarantor line. The signature was close, very close. A non-expert would have accepted it. But I had been signing documents for 40 years, and the specific pressure distribution of my pen, the slight rightward lean I carry in the capital G of my first name, the clean terminal stroke on the lowercase h of Whitfield, none of those details were precisely replicated. More critically, I recognized the instrument through which the authority had been granted. 18 months prior, I had signed a limited power of attorney for Marcus, a narrow document drafted by an estate attorney I trusted, granting Marcus authority to manage specific real property transactions during my recovery from a knee replacement. It was surgically limited in scope. It authorized real property management only. It did not, under any reasonable legal interpretation of the language I had read with the deliberation I applied to every contract I touched in 40 years, authorize the execution of commercial debt guarantees. I did not move for a long time. I sat in my study chair, the one I had owned for 22 years, the leather worn in the precise impressions of my weight, and I let the information arrange itself inside me, the way financial data always arranged itself, not emotionally, not immediately, but in the cold, structural geometry of consequence and causation, my son. The boy whose college application essays I had proofread at midnight, whose first car loan I had co-signed before I understood how much risk a proud father could absorb without knowing it. That boy had used a document I trusted him with to tie my name to debt I had no knowledge of. I understood immediately why confrontation was not an option. I had spent a career watching what happened when white-collar financial criminals were cornered before evidence was secured. They did not confess. They did not fold. They accelerated. They shredded, transferred, and restructured every paper trail they could reach, and by the time the investigative machinery caught up, the evidentiary landscape had been so thoroughly rearranged that prosecution became a years-long reconstruction built on fragments. I was not giving Marcus that window. That night, at 11:47, I placed a call from the secure phone kept in the false bottom of the cedar chest in my study, a habit born from handling sensitive internal investigations during my years at Hartwell Meridian and never properly abandoned. The man I called was Raymond Doss, a 73-year-old retired forensic accountant who had worked alongside me on 3 separate investigations during our overlapping careers, and who possessed one of the most methodically precise analytical minds I had encountered in 4 decades of professional finance. Raymond answered on the second ring, the way he always had. I told him what I had found. No dramatization, no editorializing, just the facts in the order they were relevant. When I finished, there was a brief silence on the line that Raymond used the way a surgeon uses a pause before an incision, not from hesitation, but from the gathered precision of a man readying himself for exacting work. I told him I needed a shadow audit, complete, parallel, and invisible. Marcus could not know. The family could not know. And I intended to give the evidence every advantage a 14-month preparation window could provide. Raymond said he understood, and asked when I wanted to begin. I told him we had already begun. But a shadow audit is only as effective as the cover it operates beneath. If Marcus suspected for a single moment that I was coherent, watchful, and methodically dismantling the fraud he had built on the foundation of my name, he would move. He would restructure the LLCs, transfer liabilities, and insert enough legal distance that untangling it would cost more in litigation than the debt itself. I needed him comfortable. I needed him dismissive. I needed him to look at his father and see exactly what he had apparently decided he was seeing long before the first forged guarantee was ever executed. I needed him to see an old man losing his mind. And so, I began the longest and most demanding performance of my life. Not on a stage, not in a boardroom, but at my own dinner table, in my own home, with 14 months of meticulous, invisible work waiting for me every night behind a locked study door. If you have ever had to outsmart someone who completely underestimated you, someone who looked at you and saw only a diminished version of who you actually are. I want you to leave that in the comments below. And if you want to hear how a retired CFO built a 340-page forensic case that dismantled his son's fraud in a single Tuesday morning, make sure you like this video and subscribe. We are just getting started. The first performance was the hardest. Not because I lacked the discipline. 4 decades of sitting across negotiating tables from investment bankers who wanted to restructure debt in ways that would quietly transfer risk onto Hartwell Meridian's balance sheet had given me a composure that most men never develop. But because performing confusion required a fundamentally different kind of concentration than performing competence. Competence is projecting outward. You fill the room, you command the data, you lead the eye. Confusion is implosive. You have to hollow yourself out from the inside. Quiet every reflex that wants to correct, analyze, or respond with precision, and replace it with a carefully calibrated blankness that reads as authentic vacancy rather than deliberate restraint. It is, in the most technical sense of the phrase, the hardest thing I have ever done. I started small. In the first week, I let myself lose the thread of a sentence mid-delivery, specifically mid-delivery, not at the start, because genuine cognitive decline rarely interrupts a thought before it begins. It interrupts in the middle, when the word that should come next simply is not there, and the person affected reaches for it with a particular expression that I had observed in enough relatives across enough years to replicate with some accuracy. I practiced that expression in the mirror in my bathroom at 5 in the morning, before anyone in the house was moving. I practiced the reach, the mild frustration, the small pivot to a simpler word. I practiced until it felt involuntary. The keys were a critical prop. I lost them on Tuesdays and Fridays with enough consistency that it became part of the household rhythm. Marcus's wife, Claudia, would hear me moving through the kitchen and automatically begin scanning the counter surfaces with the vaguely exhausted helpfulness of someone who has added a task to their invisible daily list without quite remembering when it arrived there. I always knew exactly where the keys were. I had placed them deliberately, behind the ceramic canister on the left end of the counter on Tuesdays, inside the folded dish towel by the sink on Fridays. The geography was precise. The performance was not. The loading dock story was my most reliable instrument. I had been telling a version of it since Marcus was in primary school. The story of my first job in Overland Park, the ledger book, the leaking pen, the canvas jacket, and it carried the natural rhythm of a memory that a man genuinely returns to with compulsive frequency because it is foundational to his sense of himself. During the 14 months, I told it at dinner, at Sunday breakfast, during a nephew's birthday gathering in March, and twice during a long drive to a medical appointment that Marcus insisted on accompanying me to. I varied the details almost imperceptibly across each telling, the way genuine memory actually works. Not perfectly consistent, but not fabricated either. Sometimes the jacket was brown canvas. Sometimes it was green. Sometimes the pen leaked on my index finger rather than my thumb. The variance was calibrated. The repetition was not. What I had not fully anticipated was the evolution of Marcus's behavior as the months accumulated. In the beginning, the first 6 or 7 weeks, he was solicitous in the way that adult children often become when a parent first shows signs of cognitive difficulty. Gentle, patient, slightly over-solicited, carrying the specific self-consciousness of a man who is not certain how to calibrate his concern. He would repeat things once, quietly, and watch me with an expression I recognized as genuine worry. I noted this. I did not allow it to move me, because I had already seen the forged guarantee, and the concern of a man who had already stolen from you is a performance of its own, even when the performer has not yet recognized that is what it is. By month 4, the patience had thinned. By month 7, it had been replaced by something I can only describe as administrative tolerance, the particular resignation of someone who has decided that a problem is permanent and has quietly begun reorganizing their life around it rather than engaging with it. Marcus stopped repeating things gently and started repeating them with a slight over-enunciation that he probably believed was helpful, and that was, in my observation, something closer to contempt, wearing the clothes of patience. He began looking at his watch during my sentences. Not every sentence, but enough that I catalogued the frequency, with the same methodical attention I applied to everything else during those 14 months. He began referring to me in the third person in conversations I was present for, which is a behavioral marker I found particularly clarifying, not because it was cruel, though it was, but because it told me precisely where I stood in his accounting of the situation. I had been reclassified. In Marcus's internal ledger, I was no longer a full participant in any conversation that happened in my presence. I was a subject of the conversation, an item to be managed, discussed, and accounted for, not a person to be addressed. I heard him tell Claudia in the kitchen one evening, while I sat 12 feet away in the living room with the television at a moderate volume, that he thought I was going to need a full-time care arrangement within 18 months. He said it with the brisk efficiency of a man discussing a logistical problem, not the slow weight of a son contemplating his father's diminishment. Claudia made a sound of sympathetic agreement. Neither of them lowered their voice by a single register. I sat with my hands folded in my lap and my eyes on the middle distance, and I thought about the cell reference grid I had been working through with Raymond the previous night, and I did not move my expression by a single millimeter. The nightly shift began at approximately 9:30 most evenings, after Marcus and Claudia had returned to their side of the property or departed entirely, and after I had performed the closing rituals of the act, the slightly labored walk to the bedroom, the careful goodbye, the mild confusion about whether tomorrow was a Wednesday or a Thursday, that I delivered with the practiced ease of a line I had rehearsed so many times, it no longer felt like delivery at all. Once the house was quiet and the lights beyond my wing had gone dark, something that had been under compression for the entire day quietly decompressed. My posture straightened without conscious instruction. The particular softness around my eyes that I maintained during waking performance hours dissolved. I walked to my study with a stride that had nothing of the old man in it, unlocked the door with the key I had never once actually lost, and sat down in front of the laptop that connected through a layered security arrangement to the encrypted shared workspace Raymond and I had built in the first week of the audit. Raymond Doss worked with the focused economy of a man who had spent decades doing this kind of work, and had long since stripped away everything about his process that was not strictly necessary. He did not speculate. He did not theorize ahead of the evidence. He mapped. He built the picture transaction by transaction, filing by filing, date stamp by date stamp, and he sent me his findings in structured reports that arrived in the encrypted workspace with the clinical precision of a document that had been reviewed 4 times before transmission. I reviewed each one with the same precision. We communicated through text inside the secured environment. We did not call each other during this phase unless the finding was time-sensitive, because telephone records, even on secure lines, are a category of metadata that a defense attorney will look for during discovery, and I had no intention of giving any future defense attorney anything useful. What Raymond found in the first 3 months of the shadow audit was worse than I had initially calculated. There were not 1 or 2 fraudulent guarantee instruments. There were 4 separate limited liability companies, each registered in Missouri within a 22-month window, each capitalized at levels wholly inadequate for the debt obligations they carried, and each bearing documentation that connected back, through signature lines, authorized representative designations, and notarized filings executed using the limited power of attorney as the authorization instrument, to my name, my credit profile, and my personal financial standing. The 4 entities were structured with deliberate asymmetry. No 2 of them shared a registered agent. No 2 of them were filed in the same month. The debt obligations they carried were distributed across 3 separate commercial lenders, none of which would have had cause to communicate with the others about the pattern of guarantees being executed in my name across the portfolio. The aggregate liability, when Raymond completed the first pass mapping in month 4 of the audit, was $15,240,000. The underlying businesses the LLCs ostensibly operated were either non-operational or generating revenue at levels so far below their debt service requirements that the insolvency was not a risk to be managed. It was a mathematical inevitability that had already arrived and was simply waiting for the lenders to act on it. Marcus had not used my name to build something. He had used my name to delay the consequences of something that was already failing, transferring the eventual liability onto a guarantor who, in his calculation, would either not notice or would not be considered a reliable witness to his own financial affairs by the time the lenders came to collect. He had guaranteed $15 million of failing debt in my name, and he had done it while watching me pretend not to remember what year I retired. The architecture of it was almost elegant in its cynicism, and I say almost because true elegance in financial structuring requires that the structure be sustainable. This one was not. It was a delay mechanism dressed as a solution, and like all delay mechanisms in financial fraud, it had a clock built into it that its architect had apparently decided was someone else's problem to manage. It was going to become my problem to solve. Raymond and I had a phrase we used during the years we worked together at Hartwell Meridian, borrowed from the internal investigation culture of the larger accounting firms we had both trained under at various points in our careers. We called it threading the needle backward. It described the forensic process of beginning not at the origin of a transaction, but at its recorded surface, and then working methodically in reverse. Backward through the authorization chain, backward through the approval layers, backward through the document trail, until you located the precise point where the legitimate gave way to the fraudulent. It is painstaking work. It is not glamorous. It requires the specific disposition of someone who finds repetition productive rather than tedious, and who understands that the most significant discovery in any financial investigation is almost never dramatic. It is usually a date that does not align, or a signature that carries one extra loop in a letter that the genuine signer never makes, or an authorization reference number that points to a document that does not exist in the registry where it should be recorded. That is where we began in month 5 of the shadow audit. Raymond had completed the structural map, the 4 LLCs, the 3 lenders, the aggregate liability figure, and we turned our attention to the individual transaction record. We needed not just the existence of the fraud, but the granular, documented chronology of each unauthorized act. We needed the kind of evidentiary specificity that survives cross-examination, that cannot be explained away as clerical error or administrative misunderstanding, and that establishes not just the what of the fraud, but the deliberate and knowing nature of the how. The first category of documentation we assembled was the signature comparison file. Raymond engaged a forensic document examiner, a former Federal Bureau of Investigation document specialist who now worked in private practice in St. Louis and had testified in 11 elder financial fraud cases across Missouri and Illinois. She worked from high-resolution scans of every signature-bearing document that had been executed in my name across the 4 LLC guarantee instruments, and she compared them against an authenticated sample set of my genuine signatures drawn from tax filings, notarized property records, and Hartwell Meridian board minutes spanning 14 years. Her analysis ran to 41 pages. In 41 pages of measured, precise, professionally hedged language, she documented 11 specific points of divergence between the signatures on the guarantee instruments and my authenticated sample set. The divergences were consistent across documents, suggesting a single forger working from a reference copy rather than multiple individuals working independently. The report was devastating and methodical in equal measure. The second category was the registry log analysis. The limited power of attorney that Marcus had used to execute the guarantees was a recorded instrument, filed with the Jackson County Recorder's Office as part of the original real property management authorization. Every use of that instrument to execute a subsequent document should have generated a corresponding notarial record, cross-referenced back to the original POA filing. Raymond requested the full notarial register from the 3 notaries whose stamps appeared on the guarantee documents. 2 of those notaries had no record in their personal registers of performing notarial acts on the specific dates listed on the guarantee instruments. The 3rd had a register entry for the date in question, but the document description in her register did not match the instrument on which her stamp appeared. This is the kind of discrepancy that is invisible to a casual reviewer and absolute to a forensic one. We documented it in a dedicated section of the audit file, with tabbed exhibits cross-referenced to the original register images. The bank transfer records came through a combination of legal instruments. Raymond's legal counsel filed targeted public records requests and worked with a civil attorney I had quietly retained to begin the formal investigative groundwork. What the transfer records revealed, across the 16-month operating window of the 4 LLCs, was a pattern of cash movements that told the story with more clarity than any single document could. Funds advanced by the commercial lenders against the guaranteed instruments had been distributed not into operational accounts in the names of the LLCs, but into a series of intermediary accounts that resolved, through the beneficial ownership research Raymond conducted in parallel, back to entities and individuals connected to Marcus. The money had not gone into failing businesses. The money had gone into the management of Marcus's personal financial position, specifically the servicing of prior debt obligations that predated the LLC structure by nearly 3 years. In total, Raymond and I cataloged 23 distinct unauthorized transactions across the 4 LLCs and the 3 lending relationships. Of those 23, 21 could be classified under Missouri's financial exploitation statutes as unauthorized use of a principal's financial resources through an agent acting in excess of their authority. 2 of them crossed a different threshold entirely. Those 2 transactions, both executed within a 6-week window in what would later become months 9 and 10 of the Shadow Audit's investigative timeline, met the specific elements of felony elder financial exploitation under Missouri Revised Statutes Section 570.145. The amounts involved in each individual transaction exceeded the statutory threshold that elevates the offense to a Class B felony. The victim, myself, met the age qualification under the statute. The perpetrator, Marcus, met the relationship qualification as a family member in a position of trust. And the method, the use of a recorded power of attorney instrument to execute obligations explicitly outside the scope of that instrument's authorization, satisfied the statutory definition of exploitation with a clarity that left no interpretive ambiguity. 2 Class B felonies. Under Missouri law, each carries a sentencing range of 5 to 15 years. I want to be precise about what it felt like to document those findings, because people who imagine forensic financial investigation as a purely clinical exercise misunderstand something fundamental about the work when the subject of the fraud is someone you raised. I have described the process in technical terms because the process was technical, and I will not pretend that precision and emotion are mutually exclusive. They are not. But I also will not pretend that the precision was easy to maintain when what I was building, page by page, was a legal instrument that was going to alter the trajectory of my son's life, irreversibly and forever. I watched Marcus during those months with a new layer of understanding that I had not had during the early performance period. I watched him take Claudia to a resort in Colorado in February. Expensive, the kind of trip that shows up in transaction records as significant personal expenditure during a period when LLC revenue was functionally non-existent. I watched him purchase a vehicle in April, a late-model German sedan, with the offhand ease of a man temporarily rewarding himself for resolving a cash flow problem. I knew where the money had come from. I was cataloging where the money had come from. Every visible indicator of his comfort was, for me, a data point in a growing evidentiary record, and I experienced the specific and deeply uncomfortable duality of documenting a crime while watching the criminal enjoy its proceeds in real time. There were evenings, more than I would have predicted at the start of this, when I sat in my study after the nightly shift had ended and the laptop was closed and the encrypted workspace had been secured. And I felt something that was not exactly grief, but occupied the same interior address as grief. I was not mourning a death. I was mourning a version of a person, the version that exists in the particular way that parents construct and carry their children internally. The version built from 30 years of accumulated observation and love and investment. And I was mourning it precisely because the actual person was still present, still visible, still occupying the same physical spaces and family occasions, but had revealed himself to be constructed from different material than I had believed. That is a specific kind of loss. It does not have the clean borders of bereavement. It has the ragged, asymmetrical shape of revision, the slow, unwilling process of redrawing a portrait you had spent decades believing was accurate. I did not allow it to stop me. There was never a morning when I sat at the kitchen table and considered abandoning the audit. The path had been chosen the night I called Raymond, and my conviction about the necessity of that path only deepened as the evidence grew more detailed and the scale of the fraud became more fully visible. What I felt in those evening hours was not hesitation. It was the cost of doing something that needed to be done, and I paid it each time it presented itself, and I went back to work the next morning. By month 13, Raymond and I had compiled what we were internally referring to as the master file. 340 pages, organized into 7 tabbed sections. The structural map of the 4 LLCs, the signature analysis and forensic document examination report, the registry log discrepancy documentation, the transaction-by-transaction unauthorized use catalog, the bank transfer analysis with beneficial ownership resolution, the statutory framework and legal citation matrix Raymond's attorney had prepared, and the chronological narrative summary that tied every preceding section into a coherent, linearly readable account of the fraud from inception to present. The file had a table of contents, an executive summary, and an index. Every exhibit was numbered. Every citation was verified. It was, without false modesty, the most thorough piece of investigative financial documentation I had produced in 40 years of professional work. And unlike every other piece of documentation I had produced in 40 years of professional work, this one had cost me something that no billable hour rate had ever been designed to account for. It was ready. Raymond and I reviewed it in a final session over the encrypted workspace, cross-checking every exhibit number, every page reference, every statutory citation. When we finished, Raymond sent a single message: clean. I closed the laptop. The question that remained was how to deploy it, and into whose hands the right version of justice required it to be placed. On the Tuesday morning that ended 14 months of the most sustained and deliberate performance of my life, I woke at 4:45 without an alarm, the way I had woken for most of my working career, the internal clock of a man conditioned by decades of early morning board preparation, refusing to accommodate a retirement schedule even years after the retirement itself had arrived. I lay in bed for exactly 3 minutes. Then I rose, walked to the bathroom, and did something I had not done without conscious theatrical modification in 14 months. I stood in front of the mirror and looked at myself, with no performance attached to the looking. The man in the mirror was 71 years old. His hair had gone fully white in the years since he left Hartwell Meridian, and the lines around his eyes were the kind that accumulate not from worry, but from sustained high-intensity concentration applied over decades. His posture, freed from the deliberate hunch I had maintained during waking hours for more than a year, was straight. His eyes were clear. He did not look like a man losing his mind. He looked precisely like what he was, a man who had been building something in the dark for 14 months and had arrived at the morning when it was time to bring it into the light. I shaved with a steady hand, not the careful, slightly tentative hand I had performed at the bathroom sink on the mornings, when Marcus or Claudia might be in the adjacent hallway. My actual hand, the one that had been steady my entire adult life, and had not lost that quality simply because I had occasionally pretended otherwise. I dressed methodically, the way I had dressed for every significant professional occasion across a 40-year career. From the inside out, each layer chosen with the specific intention of the meeting it was dressing for. The suit was a 3-piece in charcoal worsted wool that I had purchased in 2019 and worn precisely 4 times since. Twice to funerals of men I had respected, once to a board governance conference in Chicago, and once to a deposition in a civil matter that had required my testimony as a financial expert. It was the suit I wore when I needed a room to understand, before I spoke a single word, that the person wearing it was not someone to be managed or dismissed or spoken to, in the slow, over-enunciated cadence that Marcus had been using with me for 7 months. I lifted the master file from the cedar chest, 340 pages, bound in a dark blue portfolio with tab dividers and a professionally printed table of contents on the inside cover, and I placed it in the leather document case that had accompanied me to every significant professional engagement since 1994. The case was worn at the corners in the way that quality leather wears. Not deterioration, but character, the accumulated evidence of a long working life. I carried it to my car, placed it on the passenger seat, and drove to the offices of Whitmore and Kellner, the Kansas City litigation firm where I had retained counsel 6 weeks earlier. I had selected Whitmore and Kellner with the same deliberation I applied to every consequential decision. Research first, reference checks second. A preliminary meeting to assess the attorney's capacity for handling a complex financial fraud matter before committing to the engagement. The attorney assigned to my matter was a woman named Patricia Hale, a senior partner who had spent the first 12 years of her career as a Missouri Assistant Attorney General specializing in white-collar financial crime before transitioning to private practice. She had the particular bearing of someone who has spent long years in institutional prosecution, efficient, direct, not given to unnecessary preamble, with a listening quality that registered everything without performing the act of registering it. I had liked her immediately. When I had first called Whitmore and Kellner to schedule the preliminary meeting, I had given the receptionist my name and a brief description of the matter. I had said nothing about my background or the nature of the documentation I intended to present. The scheduling note that found its way to Patricia Hale's desk, I later learned, described the prospective client as a 71-year-old man with a family financial dispute. I had no way of knowing what mental image that description had produced in her mind, but I had a reasonable professional estimate, and I had dressed and prepared accordingly. The reception area of Whitmore and Kellner was quiet at 7:55 in the morning, with the particular stillness of a professional environment not yet fully activated for the day. The receptionist who greeted me showed a brief, involuntary recalibration when I stated my name, the micro-expression of someone whose mental model of an incoming client has just been revised by the physical evidence standing in front of them. I did not acknowledge it. I thanked her and took a seat, and I sat with the document case across my knees and waited with the patience of a man who understood that the next hour was going to be the most consequential he had spent in a very long time. Patricia Hale came into the reception area herself, rather than sending an assistant, which I noted as a professional indicator. She extended her hand, and I shook it with the grip of a man who had been shaking hands in professional environments since before she had entered law school, and I followed her to the conference room. I did not begin with an explanation or a summary. I set the document case on the conference table, removed the 340-page master file, and placed it in front of her, with the clean authority of a man delivering a product he is confident in. Then I sat down and told her what she was holding, in the precise, structured language of someone who had spent 40 years communicating financial complexity to boards of directors, audit committees, and external regulators. I gave her the structural overview first. The 4 LLCs, the 3 lenders, the aggregate liability, the limited power of attorney, and the scope of its actual authorization. Then I walked her through the 7 sections of the file, in the order they appeared, describing the evidentiary content and significance of each one. I told her about the forensic document examiner's 41-page signature analysis. I told her about the notarial register discrepancies. I told her about the bank transfer mapping and the beneficial ownership resolution. I told her about the 23 unauthorized transactions, and I told her about the 2 Class B felony thresholds. Patricia Hale listened without interrupting. She took notes in a precise, economical hand on a yellow legal pad that she had uncapped with the automatic ease of someone who had been doing exactly this for decades. When I finished the overview, approximately 22 minutes after I had begun, she was quiet for a moment, looking at a point on the table's surface, in the way that people with genuine analytical capability look at nothing in particular when they are in fact processing something very specific. Then she opened the master file to the executive summary page and read it in full before she spoke. What she said, when she finally spoke, was not a question or a clarification. It was a professional assessment delivered with the flat precision of someone who had spent years evaluating the relative strength of financial fraud cases. She said the documentation was the most thoroughly prepared, self-assembled evidentiary file she had encountered in private practice, and that the statutory case for elder financial exploitation under Missouri Revised Statutes Section 570.145 was, based on the materials presented, fully supportable. She asked if I was prepared to authorize her to contact the Missouri Attorney General's Elder Fraud Unit directly, bypassing the civil remedies pathway and going immediately to the criminal referral process. I told her that was precisely why I was there. The referral was made that afternoon. Patricia Hale delivered a formal criminal referral package to the Missouri Attorney General's Elder Fraud Unit, a dedicated prosecutorial division that handled exactly this category of offense, consisting of the 340-page master file, a cover letter summarizing the statutory violations alleged and the evidentiary basis for each, and a signed victim statement I had prepared in advance and brought with me that morning. The investigators assigned to the matter acknowledged receipt within 48 hours and confirmed that the package had been forwarded to the Financial Crimes Division for preliminary review. 12 days later, a civil motion for declaratory relief was filed in Jackson County Circuit Court, supported by the forensic evidence from the master file, seeking judicial voiding of the 4 unauthorized personal guarantee instruments on the grounds of fraud and unauthorized agency action. The motion was accompanied by an emergency application for injunctive relief, preventing any collection activity against my personal financial assets, while the matter was under judicial review. On the 14th day after the referral, a Thursday morning, overcast, with the particular gray flatness that Kansas City carries in the weeks before winter fully releases its hold, 2 investigators from the Missouri Attorney General's office and 2 civil process servers arrived at the office building where Marcus maintained his business operations. They entered through the lobby together at 9:17 in the morning. One investigator carried a document folio. The other carried a badge. The process servers carried the civil court filings, bound and indexed. The investigators carried something the process servers did not. Marcus was in a meeting when they arrived. The meeting ended. The guarantee instruments, all 4 of them, spanning $15,240,000 of commercial debt, were subsequently voided by the court on the basis of fraud and unauthorized execution. The liability transferred in full to the undercapitalized LLCs, whose organizational documents Marcus had constructed with such deliberate asymmetry. Those LLCs had no capacity to absorb $15 million of commercial debt. That was no longer my problem. My credit was cleared. My name was removed from every guarantee instrument in every lender's file. 40 years of financial discipline and a 14-month performance had restored, with mathematical precision, exactly what had been taken. The auditor had been audited. The audit was complete. The arrest came on a Wednesday, 6 weeks after the investigators arrived at Marcus's office. I was informed by Patricia Hale, who called at 8:14 in the morning, with the economy of a litigator, delivering a factual update rather than a dramatic announcement. 3 felony counts, 2 counts of elder financial exploitation under Missouri Revised Statutes Section 570.145, and 1 count of identity theft in the first degree under Section 570.223, arising from the fraudulent use of my identifying financial information to execute unauthorized commercial obligations. The identity theft charge carried a Class C felony classification with a sentencing range of 3 to 10 years, stacked against the 2 Class B exploitation counts with their 5 to 15-year ranges each. Marcus was taken into custody, processed, and released on bond by early afternoon. His attorney entered an appearance the following morning. I did not go to the courthouse. I did not need to see the processing to know that it had occurred. I had assembled the case. The system had received it. The machinery of consequence was now operating on its own schedule, and my role in that phase of the process was to be a cooperative and available witness, which I was, and to allow the prosecutorial process to proceed without the interference of a principal who has already done everything that was his to do. I went home. I sat in my study chair and allowed myself, for the first time in 14 months, to simply be still, without the stillness carrying any operational purpose. No encrypted workspace to open, no exhibit to cross-reference, no performance to prepare for. Just the particular silence of a room where a great deal of work had been done, now resting in the aftermath of its own completion. Christmas came 6 weeks after the arrest, arriving with its usual inevitability into a family now organized around a fact it had not been organized around 12 months earlier. The gathering was at my property, and it assembled with the specific awkward energy of a group of people who share blood and recent history in approximately equal measure and are not certain which one is supposed to govern the afternoon. Marcus was present. His bond conditions permitted it. He sat at the far end of the living room with Claudia, who had chosen to remain with him through the legal proceedings, with the loyalty that sometimes takes the form of endurance rather than belief. He had lost weight. His manner carried the compressed quality of someone managing a sustained interior pressure with no available external outlet. The rest of the family moved through the house with the cautious navigation of people in a space that has recently been reconfigured by information they are still absorbing. There were whispered conversations in doorways, abruptly concluded when a third person entered the vicinity. There were expressions carefully maintained at neutral. There were questions carefully not asked. Marcus's sister, Renee, moved between her brother and the kitchen with the helpless mediation instinct of a middle sibling who has spent a lifetime trying to reduce friction between people who generate it in structural quantities. My grandson, 14 years old and observant in the specific way that adolescents are observant when they understand that the adult world around them is performing, rather than simply living, watched everything from a chair near the window with the quiet attention of someone cataloging data without yet possessing the interpretive framework to fully decode it. I had been present for the first 2 hours of the gathering, in the version of myself that the family had known for 14 months, seated in the armchair near the fireplace, hands folded, contributing occasional fragments of conversation that carried the calibrated vagueness of a man whose hold on the present moment was approximate rather than precise. Old habits, even manufactured ones, have a momentum. I allowed the momentum to carry me through the early afternoon. Then, at 3:47, I rose from the armchair. I did not do it with drama. I did not announce it or preface it, or give the room any signal that what was about to happen was different in category from anything that had preceded it. I simply stood up straight, fully straight, without the slight forward inclination of the shoulders I had maintained for a year, and I walked to the dining room with the stride of a man who knows exactly where he is going, and has no uncertainty about what he intends to do when he gets there. I went to the cellar first. The wine I wanted was a 1996 Bordeaux from a small Saint-Emilion estate that I had purchased 12 bottles of in 2001 and had been holding in proper storage conditions ever since. I had opened 3 of the 12 over the previous 25 years, each time on an occasion I had judged commensurate with what the wine had become. I took a bottle now, and I brought it upstairs, and I set it on the sideboard in the dining room and opened it with the foil cutter and the corkscrew I had owned since 1988, moving through the steps with the unhurried precision of someone performing a practiced action that requires no conscious attention. The family drifted into the dining room with the collective gravity that a deliberate action in a shared space tends to generate. They came 1 or 2 at a time, drawn by the sound or the movement, or simply by the instinct that something was happening that was worth being present for. Marcus came last, standing just inside the doorway with Claudia slightly behind him. I poured the wine. I poured it into the good crystal, the Riedel stems that had been a gift from the Hartwell Meridian board on my retirement, kept in the locked cabinet for occasions that earned them. I filled 7 glasses, 1 for each adult in the room, with a steady and deliberate hand. Then I looked up, and I addressed each person in the room by their full name, not their family shorthand, not the nicknames that had accreted over decades of family life. Their full, correct names, with the specific and unambiguous clarity of a man reading from a document he has memorized completely. I began with Renee, her full name, including the middle name she had carried since birth, and rarely heard from anyone except in formal contexts. I moved to her husband, then to Claudia. I named my grandson with the particular care of someone who wanted a 14-year-old to understand that he was being seen and addressed as a full person rather than a peripheral presence. And then I looked at Marcus. I did not raise my voice. I have never found it necessary to raise my voice in order to be heard, and the 14 months I had just completed had only deepened my conviction that the quieter a statement is delivered, the more completely it tends to penetrate. I told Marcus, clearly, with the flat precision of a man stating a fact that has already been resolved, that I had been listening to every conversation he believed I could not follow, attending to every document he believed I was no longer capable of understanding, and operating, for 14 consecutive months, a fully functional forensic financial investigation into the fraud he had constructed on the foundation of my name and my trust. I told him that the loading dock story, which he had heard so many times that he had begun completing it for me, had never been a symptom of a failing mind. It had been the cover under which a perfectly functional one had been building a 340-page case that was now in the hands of the Missouri Attorney General's office. I picked up my glass. I told him, and I told the room, that I had spent 40 years in professional finance learning one lesson above all others, that the most catastrophic miscalculation a person can make in any financial or personal transaction is to misprice the asset they are attempting to exploit. I told him he had mispriced me by a very wide margin. I drank. The wine was exactly what 25 years of proper storage produces in a great Bordeaux, structured, profound, carrying the particular authority of something that has been allowed to become fully what it was always capable of being. Then I sat at the head of the table, and I suggested we have dinner. There is a version of this story that ends with a moral about justice and accountability, and that version is not wrong. Marcus faces trial. The fraud has been documented and filed and placed in the hands of people whose professional function is to pursue its consequences through the appropriate channels, and those channels are doing precisely that. That version of the ending is real, and it matters. But there is another version of this story that I find more durable, and it is this: the version about what it means to have spent a lifetime building something that cannot be faked, and cannot be borrowed, and cannot be exploited, because it is internal. The thing I built in 40 years at Hartwell Meridian was not a title, or a salary, or a reputation in the corridors of Kansas City finance. It was a set of instruments, precision instruments, the kind that require decades of use to calibrate properly, for seeing through the surface of presented information to the structure that lies beneath it. Those instruments are still functional. They will remain functional for as long as I am. They are not affected by the age of the hands that hold them. My son believed he was watching a man lose his mind. He was watching a man use it, quietly and completely, in the service of exactly the kind of truth that professional finance exists to protect. If you have found something of value in this account, I want to hear from you in the comments. And if you want to continue hearing stories about integrity, accountability, and the particular power of professional competence applied with patience and purpose, subscribe. I will be here. I remember everything.